Ryan and Eric, who would you say some of your favorite guests are that we've had on the podcast?
Ryan, I would say it was your dad, a Vietnam veteran that had intense action stories as well as touching and meaningful, content about, his life and yours.
That's true. I do have to say my dad, he has to be my favorite, but a close second would probably be COVID virologist.
Oh, that was amazing. I'd say it's a toss-up between Jason Weems, who is a comedian who died on stage and was resurrected to be on our podcast and raise his family and other things, other responsibilities. And we also had a Marine One, or like presidential helicopter pilot, on the show, and that was crazy.
That's a good one. That's hard to beat. So if any of that sounds interesting to you, tune into the Baggage Podcast, where four friends, a prosecutor, a doctor, a comedian, and a journalist, interview ordinary people about their extraordinary experiences. Search for Baggage wherever you get your podcast.
On today's edition of Stories from Real Life with Melvin E. Edwards. Our guest today is Oscar Vasquez, founder of EstateDocPrep.com. Oscar is an expert in estate planning who helps families and homeowners protect their assets from the high cost of probate. From creating living trusts to avoiding costly estate planning mistakes, Oscar's insights could save you thousands and provide peace of mind. If you're a homeowner, you can't afford to miss this conversation. Let's join today's guest, Oscar Vasquez, and your host, Melvin E. Edwards.
You are listening to Stories from Real Life, a podcast by engaging storytellers for engaged story listeners. Here's your host, author and journalist, Melvin E. Edwards.
Hello again, and welcome to this week's episode of Stories from Real Life. I'm your host, Melvin E. Edwards. Thanks for joining me on this week's learning adventure. As you heard in the intro, our guest is estate planner Oscar Vasquez. Hello, Oscar, and thank you for joining me today.
Well, Melvin, thank you so much for having me and allowing me to bring and assisting me in my crusade to bring awareness to estate planning. Thank you for having me.
Now, this is a very important topic that not enough people, including me, pay enough attention to. So we're going to learn some things today and get some action items so we can know what to do by the end of this episode. So we're going to use the magic of storytelling and narratives today to take a subject like estate planning or make it relevant and interesting to people who don't want or think about those types of subjects. So what led you to becoming an estate planner in the first place?
Well, as I've been in the real estate industry for 28 years, and we've helped a lot of homeowners get an estate plan in place by referring them to attorneys. And what happened is 10 years ago, an attorney would charge $600. Now it costs $5,000. I think the lowest I've heard so far is $3,500 to $10,000 to get an estate plan in place to prevent it from going to probate. And so it can be longer and longer. And then what we did is a few years ago, we ended up investing in a software that had the legal provisions. So when I understood that a estate plan, or AKA a revocable living trust, is a contract between the trustee and the beneficiary, which are your kids. So the contract is between you and your kids that the courts enforce. So then when I figured that out, I hired a couple of attorneys to write the legal provisions. So what happens is a living trust has to have all the legal provisions so the court to recognize it and it to prevent probate. It needs to have all of those. And so what I end up doing is it. And now we have a software that helps people prevent them from going to court by creating a living trust. And then on top of that, what we do is we go a little different. We are, for example, there's 3 tiers. One is the attorney. The second is what I would call us, where we are a estate coordinators to help you, explain to you, and then walk you through the process, because there's a large human element that there's a delay, because 95% of people that start the do-it-yourself software they don't complete it. And the reason why they don't complete it is because there's a lot of questions that are answered and they don't know how to answer them, right? Or they have the human element of, man, I never thought about that. What do I do? And so what we do is, because we've helped so many people, we give you a story, so to speak, right, of what other people have done in this situation and what are the things that you can do or that have been done, and then you make that decision. We don't give legal advice, but we tell you all the ways that how you can and what it means.
Okay, so how can some practical insights presented through narratives help people rethink their future plans?
Well, here's the first thing is understanding first of all, understand what a living trust does for you and understanding the benefits. So one of the things that it does, it prevents you from going to court. So here's the first thing to understand. One, why do I need a contract between me and my kids? Well, understanding that. And the reason why you need a contract between you and your kids is because the court says that if you do not have a contract, a living trust, you have to go to probate, and the court decides on what happens to your assets. That means if you have a digital product, if you have a book that you wrote and those royalties, who's going to get those assets? Who's entitled to them? Anything, for example, every state has a minimum provision. So every state, you would say, for example, California is 184.5. Anything that exceeds 184,500 combined, you have to go. The court gets involved. In Utah, it's 100,000. In Colorado, it's 60,000. So then you go in and you go like, wow, that means if I own a house, I'm going to go to probate. So going to probate means that the court decides on what happens. Well, that's only one of the negatives. The second negative is for example, in California, if you own a home that's worth $500,000. Now, it doesn't mean that you don't own it. It means that you own it. So it doesn't mean equity. It means that you own the home. You're going to pay $26,000 in probate fees, and that just for attorney costs plus court costs plus any other delays and objections for challenges. They call them. They don't call them objections in court, but they call them challenges where you have a long lost nephew that feels that he's entitled to some of your inheritance there, and that needs to be challenged. And that means that you get less or your kids get less because it's being challenged. Sometimes they just give it up if it's a small amount. Most people I've seen it where they created fraud and they just said it's only $5,000 and the attorney says it's going to cost you $10,000 to fight it. You might as well just give them $5,000. Right? I mean, and so that is, and then what happens in probate is that the courts, not only once they get in there, they say, okay, who's going to go to probate? Okay, Oscar's going to probate. Now what's going to happen is we're going to publish you. It's going to become public. We're going to publish your assets. We're going to put notifications out there and let people know Oscar has X amount of assets. He has this much money in the bank. He has this much money and this much real estate. If he owes you money or you had an agreement with him or you feel that you're a beneficiary, come forward. And then the court decides what happens to your assets. I'll give you a quick story on had a man that moved from Texas, had a family, just abandoned them. They didn't work out. He moved. This is a true story. He was a client of mine. He moved to California, had 4 additional kids, and he ended up accumulating about $3 million in real estate before he died. In California, it's like 1.5 houses. I'm just kidding, but it's so expensive out here. So he accumulated all this real estate, and the kids were he didn't have an estate planner. He didn't have a living trust. They went to probate. The kids showed up from Texas as adults, and they filed a claim. And even though the deceased did not want them to have any portion of his estate. The judge awarded them. So now it went from 25% to 1/7 because now there's 7 beneficiaries versus just 4. And I've never seen a judge say if it's your father, your mother, that everybody gets a piece. And he usually does it equally because he wants to be as fair and as possible. Even though they never had history, he didn't write them out. He didn't have a living trust. He had a will, but a will. Now I'll go into a little bit more of that. So that's how, one, you could have people to benefit from your estate that you didn't want, which is terrible, right? And or they can have people come out of the woodwork that could come in. Then what happens is, so the judge gave them out, and then it took another 18 months for distribution after the homes were sold. The judge ordered every home to be sold and to be split up equally because they couldn't get along, and it was just 2 different families, but they were all the deceased kids. So they split it up accordingly, and he didn't have it. So that would be one of the probably most awful things to why you want to have it, and you want to make sure that the people that you love and that are near and dear to your heart, or that you intend to have your asset or benefit from your asset, get it. So that's where I would say that is probably one of the best stories of how somebody got a portion of their assets, a portion of their benefit, and you had no intention of leaving it to them.
So would you consider estate planning a final act of love for families?
You know what? That's I'm going to have to use that one, Melvin. It is. I'm going to tell you, it is the final act of love because that and burial insurance, I think, is right up there, right? Because, yes, I would say absolutely, without a doubt, it is, because you set it up in a sense where not only do they have an economic benefit, but they have clarity of what exactly you wanted, especially if you have, like, when my mother died, there's 5 of us. And for us 5 to get, we come from 5 different walks of life, it felt like. As we grow up, we go different angles. We have different thoughts. She wanted this, she wanted that. And that's not what she told me. Well, that's why, you know what, you weren't around that day or whatever, right? It became, and so not only do you have it in writing and give them, and you'll have the peace of mind that there is no doubt on what you wanted to have done, where you wanted to get buried, whether you wanted to get cremated. It doesn't matter. It's all in your estate plan or your living trust that gives them that. And I think that I don't think I've ever had anybody or know of a story of anybody that had a living trust that was either 1, challenged, or 2, had the siblings ever argue or give that. So I think I would say the final act of love would be the right term.
Okay. So what is a guardianship, and how can that safeguard our children's futures?
Wow, that is huge. Now, let me give you some. I'll give you some. A guardianship, if you have a young child, okay, I'm going to show you. If you have children under the age of 18 and you and the wife go out to dinner, you leave the kids with the babysitter, and you don't come back. You get into a tragic accident, and you both become incapacitated. And when you can become, you're unconscious, you're just not there. If you don't have a guardianship word letter or a guardianship program in place, in the state of California, they take in your kids to social services, which I call child jail, right? They take in your kids. They take your kids until they figure out who is a family member, confirm that it's a family member, and that it's okay to have your kids there. The comprehensive guardian program that we have with our estate plan has 3 sections to it that are super important. And this is part of what I would call the human element of delay that happens when you're creating your living trust. And the reason why it's a human delay, because the question is, who do you want your kids to be with if you become unconscious or incapacitated for any short period of time, which is a short term is anywhere from 3 to 6 months, sometimes a year in some states, right? Who do you want your kids to be with? And we always tell people, make sure that it's somebody within an hour and a half away so your kids don't go to child jail, right? Social services, because that's a trauma that everybody wants to avoid for their kids. Then they say, okay, great. Who would that be? And it's, have a conversation with them because you should give them a copy of this guardianship award, right? So that way they know that you got elected. And we always say you choose 3 because one could be on vacation, one could be gone, or one won't be available, but they'll have that. The second portion that we have is if you die or you're no longer here and the child is underage, who do you want permanent guardianship over your child? And we always say pick 3 in case 1 are not available, like number 1, number 2, and number 3. Who do you want? And then the last provision that we've added, and we got this from an educator that we work with, and we mended it so it's all on there, and I call it the drunk uncle clause. Who do you not want your kids with, right? Or who do you not want your kids with? And then who do you want to exclude your kids to be able to be with? And sometimes in some families, that's a blessing, and sometimes it's not. But we always thought that's a question that should be answered. And having that now, how does that be used? For example, when we have it, we always say, hey, you give every one of your guardianships a copy and, hey, if something were to happen to us, we chose you to be one of the temporary guardians. You should have this. Here's the instructions. And by the way, take care of my kids. That gives the provision. So we always say, give that to those temporary guardians, and then always have one on the fridge and tell little Johnny, if something were to happen, this envelope has all the instructions of what needs to make sure that gets to an adult, right? And if they're young, teenagers, then you could have a deeper conversation on what that means. So that's where we've seen it, and then we've seen it come into play and how it helps it and how it goes into that effect.
And do guardianships expire when the children turn 18?
It's going to be in the provision. It's going to be up to you. I think it just, then you have the human element of joy and love that comes into play at that point, right? As far as the legal ramification, I think once they're 18, they come in. It can come into play. Some states will automatically void it, but legally, I think I would say it's going to be how it's written on there. But yeah, it does legally expire. However, I think if the guardian if they were nice, loving people, I think that becomes as a human, you have a reciprocal relationship with that, right? So I think under the legal terms, it doesn't expire, yes. But if you chose the right people and your kids are nice, sane young adults, then yeah, it doesn't expire. I think it grows on to that aspect.
Okay. So why is estate planning so important for homeowners, and what are the risks of not having one in place?
Wow, good question. So let me go into this, because just like we talked about probate, everybody in every state of the land has a home that is worth more than the minimum. That means if you do not have a living trust, you are going to go to probate. That means the judge is going to decide on what happens to your home. Okay? And that means, like, for giving an example, we had a couple. Rosa passed away about 6-7 months ago, and the kids came to me and said, Oscar, we don't want to sell our house, but the attorney said that it's going to cost $50,000 to go to probate in order for us to get title to the house. And he said that we can pay him when we sell the house. We don't want to sell the house. And we can't borrow money because the house is not ours, because we don't have title on it. So he's going to say that he'll put a lien on the house to go through probate, and then we can figure out after. And I said, well, okay, well, we can maybe refinance. We can go out, borrow the money. We'll figure, we'll cross that bridge when it comes to it. Well, it turns out that, they had plenty of equity. They went out. They all had unfortunate mishaps that happened financially and were unable to get a reasonable loan. They had to get a hard money loan. And and the attorney worked with them, but they still got put into a pretty bad loan that they still had to. So not only were they grieving, but they had to get into a terrible loan or a terrible financial situation because a living trust wasn't in place. Now, I always tell parents that in our live workshops and seminars, listen, you're doing this for your kids. If economics, if you can't afford the software and to be able to do this, divide it by your kids and tell them, listen, for you guys to save money, I need to do this document and this needs to happen because you're going to have that, because you're going to go to probate. And then obviously we went over the probate stories on what can happen in probate with your assets by the judge being able to decide that.
Principles First is headed to the George W. Bush Presidential Center in Dallas to discuss the future of American leadership. Join us for an evening of good food, great company, and engaging discussion on the campus of Southern Methodist University in Dallas, Texas on Tuesday, March 25th from 6 p.m. to 8 p.m. The featured speakers will deliver keynote remarks and participate in a discussion entitled The Future of American Leadership and Foreign Policy. Go to eventbrite.com and search Principles First to secure your tickets. See you in Dallas on Tuesday, March 25th.
All right. So what is the difference between a will and a living trust? And which one is better?
Another great question.
Which one's better for most people?
Yeah. So I'm going to tell you, that is probably, when people say, I already have a will, is the biggest misconception of having a living. I don't need a living trust because I'm not rich. That's the first largest saying, that a living trust or an estate plan is for the wealthy. If you own a house, you are now considered wealthy, right? That is it. I mean, you are considered wealthy because you meet the threshold of probate. That's the first thing. The second thing that you want to understand, in layman's terms, a will, I like to describe it as, I love you, I leave you everything. There's no instructions. It's 2 pages, if at all. If an attorney wrote it, maybe it's 3 pages. But if you did a template, it's maybe 1 page. It's a 1-page document that he's entitled to it. This is what it is. However, if you get that, a living trust, another page, is a minimum of 45 pages of legal jargon, right? Of legal provisions. I shouldn't say jargon. Legal provisions is what it has. And that is the only document that prevents you from going to probate. So that's the only provision that has the courts not coming in. So a will is a document that is also used and the courts take into consideration. So they say, Oscar wanted this. Melvin, this is what he wanted. Okay, great. Let's publish it. Let's go out and make sure nobody shows up and he doesn't owe any more money. Then what we'll do is then we'll distribute it according to what he wanted. Now, the judge takes that into consideration. However, he does not always follow that. He considers that, but the end decision is the person that's on the bench. So they still decide on what happens to your home, right? Haven't seen anybody say, I'm going to give it to somebody else or a third party. But once the monies are there, if people come forward, then it usually, that's where it starts to get very, very expensive by just having a will. And the difference between a will and a living trust, and the reason why it's so strong, is that a living trust owns the asset. You have to fund it. There's 3 things that make a living trust a legal binding document. Not only it's the provisions. Obviously, that's a taken because it's 145 pages. The provision, the actual thing is, 1, it needs to be signed in front of a notary, which a will can also do that. 2, it needs to be signed in front of 2 witnesses. You could also do that with a will. However, a living trust you have to fund it. In other words, you have to put the funds or the asset into the living trust where the asset is owned by the living trust. You control it. You can change it. When you're alive, you can change it, modify it, do anything that you want to sell it, live it, rent it, disinherit something. You can do anything to your living trust while you're alive. Once you die or once you pass, should be a better word, right? Once you pass, you'll be able to, nobody can make any changes to it. It's done. It's now law on what you want to have happen, and the executor executes your wishes. So there is no debate. And who am I going to choose? Any one of your children, because they're going to follow what you wanted. There is no, Johnny and Mary have to have a debate on what's going to happen. There isn't, because everything's covered in the living trust. There is no doubt on what's going to happen. So the person that you choose to become your executor just has to be responsible. That's it. That's the main requirement. Be responsible. They can't touch the money. They can't, distribute the money. They distribute the money, but if there's any foul play, the courts get involved. And that's where that angle of the courts is saying, hey, wait a minute, you did this incorrectly. Now, if you have a larger estate where there's a lot of moving parts, there's a provision called a protector provision, where it protects you, where they have somebody that supervises the executor to make sure that, the more things that you have and the more moving parts and the more cash, there's a lot more supervision that you need, because they don't want to make sure no quarters and dimes are being missed when you're in there. Make sure things are done appropriately. For as far as the will, and so funding the living trust. Now, this is another thing that is a difference between us and a attorney. An attorney, once you pay the attorney $5,000, the attorney gives you a 9-page document. I've seen it up to 9 pages. Some of them just tell you, here's this document, go record it. They say, to protect your home, here's the instructions of everything that you need and all the provisions. Good luck, here you go, because they're a service. Now, estate planning is one of 11 things that what we do is to help people. We are there to coordinate, educate, and walk you through the process, and we make you through all the way through funding. Now, another thing that attorneys charge for, and the reason why it gets so expensive, is they have, every time you have an asset, or every time you want to have an asset, you need a funding letter. That's another $300, $400, $500 to be able to move the asset in. So that's why most people, when they move them in, they don't take them out, they don't move them, they try not to do that. With our software, you have unlimited letters. You can change it, make it, modify it, no additional cost. You pay a one-time fee, which means, just for the simple provisions of restatement of having that. I'll give you an example. A living trust, the younger you are, the more modifications you're going to make to the living trust. The older you are, you're kind of got all your stuff settled. You're kind of getting the dust settled. It's kind of done. You're there. But what happens is, for example, you created your living trust dated May 1st, 2020. And then in January of 2025, you ended up getting an extra grandchild, and you say, you know what? I want to make sure they get some funds to go to school. If they liquidate the house, I want to be able to put some funds away. So you hold that in the trust, and then what you do is you add it onto and it's called a restatement. It goes on top. It says, I want to modify my living trust from 2020 and to 2025, and here it is. And then every time that you make a change, it goes like that. Now, to do that, yes, you have to redo the 145 pages. You have to redo all that. Our software makes it simple, so you can update it and do it on your own. Now, the first time that you meet with us, we walk you through the entire process, all the way through the process until you have a signing ceremony. And the signing ceremony means that your living trust is now active, and then we help you fund it. And then we help you and we stay in touch with you to have a provision to be able to look at your living trust minimum every 3 years. I'll give you an example. One of the things that we had I call it the tattooed son-in-law syndrome, where mom and mom and daughter went to Puerto Vallarta, got in a car accident, and they both passed. Father calls and says, Oscar, can you help me? He was about 85 at this time. And he says, can you help me go and log into that damn thing we got and update our thing, because I want to make sure that my assets, which he had a nice little nest egg of a retirement account and some couple pieces of real estate. I want to make sure my assets don't go to my tattooed son-in-law. That's why I called, because he always referred to him as this. He seemed like a nice guy when I talked to him, but that's how he referred to him, right? And I want to make sure that damn kid doesn't, have a party on my money, on my dime. And I said, okay, well, that's fine. We'll get it. And he goes, but before I go, I'm going to go see my sister in Texas. She's not doing well, and I'm going to do it. He never came back. And the provision that he wanted to put was, I want all of when the day I die, I want my assets to skip my son-in-law and be held in trust for my grandchildren. So what happened? The son-in-law ended up inheriting 50% because he only had 2 children, the son and the daughter, and the daughter and the son-in-law ended up with half of his estate legally, because he was not excluded. Now, because of that, we ended up putting a provision, and now we ask that question. Now we ask that question up front, right? When you create your living trust, now we ask it up front. So we don't have to go back and update it now. If your daughter doesn't make it, or something happens and she dies before you or after you, do you want your assets are you okay having your assets going? You want it to go to your grandchildren, or do you want it to go to your in-law? And like 99% of them go, no, I want it to go to, but it's a provision that you don't think about until it happens, or until you hear that story that, oh my God, how terrible. Well, it was a great windfall for him, right? And hopefully he did the right thing and saved some money for his kids, because the man left. He was an engineer and or a chemist or something for a company called Northrop, some chemist company here in Thousand Oaks, where he did very well. He put a lot of money. He sacrificed a tremendous amount of his pleasures to make sure that his kids were taken care of, right, at that time. And he was fortunate enough to do it. And he left a nice little nest egg there. And so hopefully that kid does the right thing and keeps it for the grandkids.
Okay. So why do you think 68% of Americans don't have an estate plan? And how can you help change that mindset today?
Wow. And this is all why I started that crusade. I read that probably in September of 2024. When I read that, I really just meditated and asked myself that question: how is that even possible? And I came up with 2 conclusions. It's 2 reasons, I think. One is that they know they don't care about their kids. They just say, you know what, let them damn kids deal with it on their own. They can deal with it. That's the first reason. And the second is that I think they don't know. They don't know that their kids are going to have a financial burden, or somebody's going to take from them, right? I call it take because they're forced to do it. They're not doing it by choice. The choice is, if you don't do it, the house doesn't go to, if you don't pay the attorney, the courts are not going to recognize it, and the house is going to get lost. So they're forced. That's why I call it take. And so then I said, what is one of the ways? And I said, I'm going to start reaching out to podcasts and create an awareness campaign. So now I can tell people, now that you know, you can't not unknow, right? Now the choice is yours. And it's kind of like that saying, that once you've seen it, you can't unsee it. You know it. Now you know that you're going to go. If you own a homeowner, you don't have an estate plan, and you don't take action in the estate plan, then guess what? That's going to be by choice, because now you know what you didn't know, which is that you need an estate plan. You need an estate plan in place to prevent it from going to probate, which is going to save and give your kids peace of mind. Listen, we can't take it with us. Right? 1, 2, if we know how to prevent ourselves, and I could tell you, The majority of our customers and people that we've helped are probably the age of 45 and 50. Very, very few do we get anybody in the under 45s, but it's usually about 45. The ones that do it under 45, they know somebody that that went through probate, and they're like, I do not want that for my kids if something happens. Or they know, or they lived through it, or they had a friend or a cousin or a family member that went through it. And those people take massive action, and they seek us out, right? Because they've seen what people go through when it goes to probate. So I always tell people, look, if you have any questions, I'd love to give you a 24/7 client assistance, artificial intelligence receptionist phone number. You can call it, ask it any question you want about estate planning. She's not there to sell you. She's not there to gather information. We do this because we want it to be a non-threatening phone call that you can talk to an artificial intelligence. We programmed her. She has every state of the land's law. She understands it. She say, can I do this? Can I do that? How does this work? And you could do that. Once you're ready, and the phone number that I like to give you is 805-909-4689. You can call it. She works every day. Every day. She never takes a day off. She doesn't call in sick, and she has no vacation days. So she's a true trooper. And she's available 24/7. So that's 805-909-4689.
Okay. So what specific steps should homeowners take today to protect their homes and other assets?
Okay. Well, the first step is that I would recommend that you make the decision and talk to your kids about what you want to have happen. I think that it all starts with the conversation. It's not taking action and getting a living trust. That's probably the third or fourth step. The first conversation is to think about if you want to be able to have peace of mind for your kids and have that thought, and then have a conversation with your children and say, hey, this is what I'm going to do this, and this is what you're going to do. This is where I want it. If you have that open communication, if you don't, then you need to take action and start the living trust. Now, a living trust can be created in as little as, I've done it the fastest. I didn't do it. One of our agents did it. He did it in 3 days, and basically had a customer was in the hospital, went to the hospital, created it. It was a very basically, the only thing he wanted for the living trust is for his kids not to pay any probate fees and get the new assessment. And they created it. They created on a Saturday. They printed everything, got it signed on Monday, went to the courthouse, recorded it, put it into the living trust, and the man died that Friday, which was terrible. But the kids, were all there. They were all watching him answer all the questions, and this is what I wanted. It was an experience. The agent told me that he didn't realize, but he was determined, right? He knew he was sick, and he knew he felt the way he was answering questions. It wasn't a thought. It was, this is what I want done. This is what I want. It was decisive. And he got him done. So the first step is have a conversation. The first step, if you're a homeowner, the first step that you need to do is have a conversation, and have a deep thought process of what you want it to look like when you're done, when you're gone. The second step is have a conversation with your kids. And the final step, and I think in the process to start your living trust. There is no expiration date with our software. You can take as long as you want. I always tell people, make it simple, protect the largest asset, which is your home, get it in there, get it funded, because you have unlimited revisions. Unlimited revisions means you can make changes as many times as you want. It costs nothing. Yes, you will have to pay the notary again, but that's $15, right? But if the decisions and the changes are that important, then my recommendation is to pay the $15, right? If they're that important, the importance to the cost. Or if they're small things and they're not that important, then wait until you have more things, and then you can sit there and do it. The good thing is that you'll have access to it. You'll have access to it 100% and 24 hours a day. Now, the first time that you do this process, we do 3 calls with you. And the reason why the first call is we walk you through the entire process. We have you, this is where you upload things. Go ahead and fill this out. We spend about 45 minutes on the first call with you. We want you to go through it and say, okay, get a pen and paper. That's homework, because that you need to talk to your kids about if you want to talk to them, or you and your spouse need to have that conversation, right? And the biggest conversation, I think, is when they're younger adults, is do you want to allow your spouse to make changes to the living trust to the beneficiaries when you're no longer here? The wife 100% says, no, I don't want him to. The husband always says, yeah, go ahead and let her make changes. And I always ask, I know the answer, but I ask, I say, so tell me, why don't you? Are you kidding? He's going to remarry 10 days after I'm dead. And the next girlfriend, if she doesn't like or the next wife doesn't like my kids, she's going to convince him to inherit them, and this dummy is going to do it. And I'm like, okay. But I get that story a lot, but it's amazing because every wife has a different reaction on how they answer that question. It's the serious ones, and the ones that I think are there, just that's what I want. Those are the ones I go, okay, sorry, no reaction, just boom, solid. So those are the steps that I would recommend.
Okay. So what is the typical cost of setting up a living trust, and how does it compare to the cost of probate?
Okay. So a living trust cost, we'll go over all the attorney costs. So the attorney costs would be, for example, an average attorney costs about $3,500, and the average cost is $3,500. I've seen them go all the way up to $10,000-$15,000 for an attorney. Then you have what's called maintenance cost. Maintenance cost means when you need restatements, you need funding letters and all that. And so $3,500, and then a restatement, the average attorney charges anywhere from $1,200 to $1,800 to do a restatement. Okay. And then you have, notary, those are notary fees that you have, and each notary, depending on if you do it. Now they can do it online. So you can, if you're able to do video, they can notarize you online. And that's, $10, $15 to be able to do that. The next cost that you have is that you include into the living trust is going to be to record the documents. These are all the costs that include. So I think that if you get in a cost with an attorney, just to get it out the gate from start to finish, it takes the attorneys, not because it's that complicated. It takes that long because they are so far behind, because so many people are starting to take action. It takes about 45 days and about, I would say, $5,000. If you use our software, there is a one-time charge that you pay. And once you pay that one-time fee, on our website, we have it at $24.97. $24.97 for a lifetime access and unlimited revisions. What we do is on the annual basis, we charge $129. We can update the annual provisions from each state. That each state gets, the annual provisions gets updated every year if there's any major laws that happen. So we do that. So that way, if the provision it's documented, your documents never expire, by the way. However, if you make a change and there's a new provision in that state that they want to have in there to have it recognized, that's important to have, right? Because you do not want to have a living trust that's not there. So that's $129 a year. And it's only for the years that you make the provision. So if there's no changes that year, don't need to have it. Don't need to pay the $129. So it becomes like a membership that you can renew, start, and stop at any time. Then if we can, I'd love to give out that we have a discount code.
For the listeners here, this is something special that Oscar has available for.
Yes. And so what I did is I wanted to give you guys for the first 10 people that listen to the podcast and take action, I want to give you $1,000 off. So you used a discount code, Real Life, You can do it all caps or whatever. Real life for the first 10 listeners that get a living trust, unlimited updates, and you still get the personalized service, and you can save $1,000. That means your checkout would be $14.95 one-time fee for real life is the discount code for the first 10. So as long as the first 10 come out, you'll be able to get that, take action. And the reason why I do that for the first 10 is because, one, we want people to take action to be able to have an incentive to be able to save money over the long haul. Listen, if you got 3 kids, 300, that's $500 a piece, right? If you can't afford it, get your kids to pay for it. I always say they're the ones that are going to benefit from it anyways, because they're going to save the 26 in California. If you own a house, a condo, a mobile home, it's going to cost you $26,000. So $1,400 versus $26,000. If you tell any one of the kids that, the first thing that they're going to do is go after it, right? They're going to go do it. They're going to definitely do it because it's worth the $300. Because guess what? 2 things are guaranteed in life. 2 things. One, well, if you live in the United States, the 2 things are guaranteed. One is you're all going to pay taxes. We all going to pay those taxes. Doesn't matter what state you in. It just some states pay less and more. However, we're all going to pay it. And the most important thing, we're all going to meet our maker someday. We all going to die. That's going to happen. So if you've been fortunate enough to be and had the blessing to have and be a homeowner, you have to have it. If you have a business that has assets that exceed the minimum requirement in your state, Google it. How much do I have to have what's the minimum I have to go to probate? If your assets exceed that in your business, like I just did a person that has a YouTube channel, he generates $3,000. I said, well, you know what? It's $3,000 a month. I said, okay, but what do multiples sell for, right? They sell, because when you sell a business, it's a multiple of how many months. It sells for 5 years worth of income. So the business is worth about $100 and some thousand, right? It's times 6. So 3 times 6, $180,000. That's what it's worth. And he goes, wow, I did not know. I said, well, I didn't come up with that number. We YouTube did, and ChatGPT, and kind of did some research to see what do YouTube channels sell for. And that's what they sell for, because those videos keep on generating income even after you're done. And he goes, wow. So, I mean, I didn't realize that. And he goes, what should we do if I die? What are you going to do with the money? Now you can give the money straight out to your kids, or you can put it into a fund to make sure that your grandkids have money to go to college if they have that opportunity. Most of us growing up, my mom said, you get 2 things. You get a warm place to stay, and if we have food, you get to eat. And if we don't, then we all going to share the same soup. No, that's not true. We never went without a meal. We were always blessed, even though my mom always gave us that, right? And that's one thing that we never knew. You're bringing me back to that. Never knew how poor we really were, because my mom was a great provider as a single mother. She raised 5 kids. My father passed in 1976. I was 5 years old at the time. My mother worked 3 jobs. And I used to always tell her, she goes, man, Mom, I used to love you when she'd make those homemade flour tortillas, and we would do that. She goes, yeah. I said, but why do we always have them on Saturdays? She said, because the church gave out the flour on Saturday mornings. And I was like, wow, that's a story when you go back and you go like, really, Mom? Yeah. She goes, why do you think no matter what, your mother always gave $20 to the church? And I was like, that's amazing, Mom. That's a blessing in disguise, right? So anyways, I know, what does that have to do with estate planning? No, but I got to tell you, it reminded me about preparing for your kids and being able to provide, because I think that is our legacy. That is what we have. That is who we are. And we can't take it with us. And I think if we can leave them one thing, that would be an estate plan, so that way they can have a time to grieve and be able to remember that you thought of them.
Well, the connection there with your story of your mother is these are all the stories from real life. That's real. That's part of your life story.
Yeah, you know what? That's true. There you go. Yeah.
And I appreciate you sharing.
Sorry, getting a little emotional about that, but it's been 14 years, but it's like yesterday, brother. It's one of them things you don't forget.
I know what you mean. So our guest today has been estate planner Oscar Vasquez. Oscar, thank you so much for joining me today and sharing your knowledge with my audience and sharing your information about your business. Looks like you got one more thing to say.
Yeah, I got one more gift and I forgot to say it. I want to give everybody a free comprehensive guide. And this is a download. It's like I think at this time right now, it's about 42 pages. Just because you answer all the questions on there doesn't mean you have a living trust. But this comprehensive guide goes through everything that you need, all the questions. And I use it as a guide because it helps you through the human element of delay. Because wow, I didn't even think of that. And it gets it on there. You can get that at estate.prep.com/guide, estate.prep.com/guide, and you can download it absolutely for free. I wanted to give that to you because I think if you're a homeowner, you need it. If you have young children, you should get it. If you're a business owner and it has assets, you need to have it. So thank you very much, Melvin. Sorry to throw that in at the last minute.
That's okay. And I'm going to post all the links that we discussed today in the show notes so that the listeners can have access to those discount codes and the guide that you just mentioned. So thank you again for adding that.
Thank you.
So if you don't already follow this show on Spotify or some other podcast platform, I would appreciate it if you would do that now and share it with others because everybody needs this type of information, this type of advice, and have them reach out to Oscar. He can answer the questions. So that's it for today's episode of Stories from Real Life. Join us again next time for another chance to learn from each other's stories and journeys. Until then, don't forget to shine your light wherever you go.
That was Stories from Real Life. Join us again next week for another great storytelling journey. See you next time.